PVL3702 Law of Contract, Chapter 4 Improperly Obtained Consensus. Number 4.1 Introduction. Where a person enters into a contract on the strength of a misrepresentation made to him or her, or as a result of duress or undue influence exerted upon him or her by the other party, the agreement is nonetheless real for having been induced by such means. There is no lack of consensus, as in the case of material mistake, since the parties know precisely with whom and on what terms they are contracting. The agreement is accordingly a valid one, provided of course that the other elements necessary to constitute a contract are present. However, since the consensus of the parties is vitiated or flawed, in that it has been obtained by improper means, the contract is voidable at the instance of the innocent party. In other words, if he or she so wishes, the party misled, coerced, or unduly influenced into giving his or her consent may set the contract aside, or have it set aside by the court, in which case each party must restore to the other party any benefit that he or she may have received under the contract. However, until such time as it is set aside, the contract remains valid. Number 4.1.1 Restitutio in integrum. The remedy of rescission coupled with restitution is known as restitutio in integrum. Originally granted by the Roman praetor on the grounds of dolus, that is fraud, metus, duress, or minority, it has in modern law become the remedy used to set aside a contract that is voidable on any of a number of grounds. There is no need to approach the court for an order of cancellation. An extrajudicial repudiation will suffice. Where the right to rescind is repudiated, however, it is desirable to obtain a court order confirming the cancellation, since third parties may act on the assumption that the contract still exists. Restitutio in integrum is available both as an action and as a defense to a suit on the contract. In either case, it is aimed at restoring both parties as far as possible to the positions they occupied prior to entering into the contract. Since the remedy is governed by substantially the same principles as applied in the case of cancellation for breach of contract, we need here merely state in brief outline the position of the party entitled to the remedy. Whether the ground for relief is misrepresentation, duress, undue influence, or bribery, the innocent party is faced with an election either to rescind the contract or to uphold it. His or her decision, once made and communicated to the other party, is final and irreversible without the other's consent. If the innocent party elects to uphold the contract, he or she remains bound on the terms or by its terms. On the other hand, if the innocent party elects to rescind, he or she must notify the other party of this decision, and the contract comes to an end on receipt of such notice. A duty then arises on either side to restore any performance that has been made in terms of the contract. As a general rule, the innocent party's right to claim restitutio in integrum is dependent on his or her own willingness and ability to return what he or she received under the contract. But as in the case of cancellation for breach, the court will relax this principle where considerations of equity or justice so demand. If the other party is unable to make restitution, the innocent party is entitled to claim the value of the performance that he or she made. The right to rescind a voidable contract is lost in exactly the same way as the right to cancel for breach of contract is lost. For example, by affirmation of the contract, waiver, or prescription. Number 4.1.2 Delictual damages. The conduct of the party who induced the contract by improper means will frequently constitute a delict. Where this is the case, the innocent party may recover damages in respect of any financial loss that he or she has suffered as a result of the delict, irrespective of whether he or she elects to affirm or to rescind the contract. In spite of the contractual context, the damages are delictual in character, and therefore governed by the principles applicable to the actio legis aquilae. It follows that the damages are measured according to the innocent party's negative interest. That is, they aim to place him or her in the financial position he or she would have occupied had the delict not been committed, which in the present context usually means the position prior to contracting. As such, the award of damages supplements and reinforces the restitutive character of restitutio in integrum, where the contract is rescinded. To the extent that the innocent party, despite restitution, is still worse off as a result of having concluded the contract, due to wasted expenses and other such consequential losses, he or she may demand compensation to restore his or her earlier position fully. Where the innocent party chooses not to rescind the contract, his or her damages include also the loss, if any, that he or she has incurred on the transaction in question. For example, by paying more for a thing than it is worth as a result of the delictual conduct of the other party. Then there is just a quick pause for reflection. Are these remedies all delictual in nature? In the text above, we have treated the remedy of rescission followed by restitution as being a remedy afforded by the law of contract, and this quite distinct from an action for damages that must satisfy all the requirements for delictual liability. In earlier editions of their work, Van Heijsteen et al. Adopted a different approach, creating the impression that they regarded even the remedy of rescission and restitution as being essentially delictual in character. In line with this approach, they recast the requirements for the rescission to make them conform to the elements of liability in delict: an act or conduct, wrongfulness, fault, causation, and the undesirable result, contract or damage. As will become apparent from the discussion in the rest of this chapter, the courts do not treat the requirements for restitutio in integrum in this manner. Does it make the law any clearer when the requirements for rescission are refashioned to make them fit the delictual pattern in this way? Even to the context of modifying the damage element to undesirable result, to accommodate the fact that damage or financial loss is not usually required for rescission. 4.1.3 A general ground for rescission. Apart from minority, which is a special case, there were originally two grounds on which an otherwise valid contract could be set aside: fraud, that is dolus, and duress, metus. In modern times, further grounds for rescission have been recognized. Fraud has been extended to encompass non-fraudulent misrepresentation, and undue influence has been accepted as a ground distinct from duress. Most recently, a fourth ground has been added to the list: commercial bribery of an agent. These developments raise the questions: is there a closed list, numerous clauses of grounds for avoidance, and are the specific grounds already recognized not simply manifestations of a single, more general ground? The common denominator linking the recognized ground is undoubtedly the fact that one party has obtained the consent of the other party to the contract by means that the law considers illegitimate. And despite suggestions sometimes made that the reason for setting the contract aside lies in the defective will of the latter party, it seems now to be clearly accepted that the underlying principle is that no person should be held bound by a contract to which his or her consent has been improperly obtained. That being so, it can be predicted with some confidence that in the course of time new grounds for avoidance will gradually emerge, either as distinct defences in their own right, as occurred with commercial bribery, or as extensions of existing ones, as might be expected in the case of economic duress and abuse of circumstances. Whether the specific grounds will one day be subsumed under one general ground, thereby obviating the need to establish the various elements of each particular defense is much more doubtful. For the time being, the courts appear to have set their face against such a development. 4.2 Misrepresentation. A misrepresentation is a form of misstatement, whereas misstatement is simply an assertion that does not accord with the true facts. In the law of contract, the term misrepresentation has gradually acquired a narrower, more technical meaning, namely a false statement of past or present facts, not law or opinion, made by one party to another before or at a time of the contract concerning some matter or circumstance relating to it. Although it usually takes the form of an express verbal statement, a misrepresentation may also be implied by conduct. In many cases, such as when rust patches are concealed by the seller of a car, the implication of the seller's conduct is obvious. But in others, the process of extracting the representation from the acts and conduct in question is rather more complicated or subtle. In some circumstances where there is a duty to speak, even silence may constitute a misrepresentation. The state of mind with which a misrepresentation is made determines to some extent the remedies to which it gives rise. Misrepresentations are accordingly classified as being fraudulent, negligent, or innocent. A fraudulent misrepresentation is one made first, knowingly, or secondly, without belief in its truth, or lastly, recklessly careless whether it should prove to be true or false. More concisely, it is one made without an honest belief in its truth. A belief is not honest, which, though in fact entertained by the representer, may have been itself the outcome of a fraudulent diligence in ignorance. The test of honest belief is subjective. Negligence or unreasonableness, however gross, cannot constitute fraud, though it may help to persuade a court that there was in fact a want of honesty. A negligent misrepresentation is one made honestly but carelessly. An innocent misrepresentation is one made without fraud or negligence. Until fairly recently, the appellation innocent was applied indiscriminately to all non-fraudulent misrepresentations. But today, with the emergence of a remedy in damages for negligent misrepresentation, it should be reserved for misrepresentation made without fault. Number 4.2.1 Misrepresentation distinguished from other pre-contractual misstatements. Misrepresentation should be distinguished from other misstatements that may be made in the course of negotiating a contract, for the remedies available to the party differ considerably according to the type of misstatement in question. If, as may happen, the categories of misstatement overlap, the party misled is entitled in principle to a choice of remedies. Number 4.2.1.1 Warranties or contractual terms. When a statement of fact is made during the course of pre-contractual bargaining or is embodied in a contractual document, for example, the car is a 1985 model, it is often a nice, subtle question whether the statement is a mere representation or a warranty, that is, a term of the contract, something to which a man must be taken to bind himself. The classic test for distinguishing warranties from representations focuses on the intention of the parties. Did they intend the statement to form part of their contract? In other words, was the intention that there should be a contractual liability in respect of it? For whereas the maker of a representation assumes no responsibility for his or her statement, though the law may impose such responsibility upon him or her, a person who warrants or guarantees the correctness of his or her statement agrees to be liable if it should prove to be incorrect. We have to ascertain whether both parties intended to contract that the thing sold should be as represented, whether the seller intended to bind himself in law that the thing would comply with what he had stated, or at any rate so acted as to stop himself from denying such intention. This insistence on animus contrahendi for a warranty has justifiably been described as a general principle of unimpeachable propriety. But one apt at times to be elusive in the matter of its practical application. In determining the intention of the parties, the court is guided by objective criteria such as the importance of the truth of the statement, the stage of the transaction at which it was made, and whether it was made in response to a query by the representee. But of course, none of these tests is conclusive. Moreover, as the passage quoted above makes clear, even in the absence of a genuine animus contrahendi, a person may be held to have given a warranty on the basis of estoppel or the principle in Smith versus Hughes, if he or she led the party reasonably to believe that he or she was warranting the truth of his or her statement. Since a warranty is then a term, its breach gives rise to the usual remedies for breach of contract, including cancellation of the contract, where the breach is material, and damages measured according to the aggrieved party's positive interest. In other words, the aggrieved party may demand to be placed in the financial position he or she would have occupied had the statement been true. Finally, if a misrepresentation made prior to the conclusion of a contract is subsequently incorporated into it as a contractual term, the representee may sue either for misrepresentation or for breach of contract. Number 4.2.1.2. Opinions, statements as to the future, and statements of law. Since a representation is a statement of past or present fact, mere expressions of opinion, forecasts, or statements of intention that prove to be incorrect or are unfulfilled will not usually amount to misrepresentations. However, since the state of a man's mind is as much a fact as the state of his digestion, if the speaker does not in fact hold the belief or opinion which he or she expresses, or lacks the will to give effect to his or her statement of intention when he or she makes it, he or she misrepresents his or her own state of mind, and for this he or she may be held liable. It is difficult to imagine a person misrepresenting his or her state of mind other than fraudulently. But in England, the Court of Appeal has held that in exceptional circumstances, a bona fide expression of opinion may imply a representation that the speaker has reasonable grounds for holding the opinion. A statement of law has traditionally been considered to be one of opinion, rather than fact, and therefore not actionable. Even if this is still accepted, which seems doubtful, it follows from what has just been said that if the maker of the statement does not in fact hold the legal opinion in question, he or she makes a misrepresentation of fact. And likewise, perhaps if he or she impliedly represents that he or she has reasonable grounds for such a belief. It is often very difficult to say whether a statement is one of fact or law, particularly when it purports to apply the law to the facts of a concrete situation. A statement as to the legal effect of a document is one of law, but where a party induces another to enter into a contract by representing that he or she places a particular construction upon a clause in the document, he or she will be bound by that construction even if it is not the legally correct one. Number 4.2.1.3. Puffs or simplex commendatio. Anyway, mere general laudation, puffery by a contracting party does not amount to misrepresentation if he or she confines him or herself to indiscriminate puffing and pushing and does not condescend to particulars. Simplex commendatio non obligat. The party is merely singing the praises of his ways, as sellers have ever been wont to do, and the other party is generally expected to be aware of this fact. This to describe a house as a desirable residence for a family of distinction, or even as well built, is not to make a representation of fact. However, if the statement goes beyond loose praise and commendation, so that the exaggeration or puffing is intermingled with facts and punctuated by details, it may well entail liability. In such a case, the whole of the compound statement must be considered in order to decide whether it constitutes misrepresentation or puffery. It is often difficult to draw the line between the two concepts, but the question is one of fact to be determined objectively by the court on the facts of each case. Puffs are, of course, a type of opinion, and the suggestion has been made that the real reason for non-liability in respect of puffs, opinions, and statements of intention is that reliance on such statements is not reasonable. 4.2.1.4 Dicta et promissa. Superimposed on the distinctions drawn above is a concept derived from Roman and Roman Dutch law. A dictum et promissum has been defined as a material statement made by the seller to the buyer during the negotiations, bearing on the quality of the res vendita and going beyond mere praise and commendation. If such a statement turns out to be unfounded, the purchaser has at his or her disposal the ancient Delictian remedies. That is, he or she may cancel the contract with the actio redhibitoria or sue for a reduction in the purchase price with the actio quanti minoris. As defined, the concept of a dictum et promissum cannot be confined to any of the categories mentioned above. Clearly, it excludes puffing and is limited to the contract of sale. Within its narrow sphere of operation, it amounts to a form of representation. However, as with all representations, it may be guaranteed, in which event it constitutes a warranty, breach of which will give rise to the usual remedies for breach of contract. Should he or she prefer, the purchaser retains the right to claim a Delictian relief instead. Then you can just study that figure on your own time, figure 4.1. And then number 4.2.2, misrepresentation and mistake. Misrepresentation and mistake are closely related but distinct legal doctrines. All actionable misrepresentations induce a mistake in the literal sense of a misapprehension, since the representee has no grounds for complaint if he or she was not misled by the false statement. However, it is by no means true to say that all misrepresentations raise the technical doctrine of mistake. The misapprehension induced by misrepresentation usually amounts to no more than a mistake in motive, which cannot invalidate the contract ab initio, since it does not exclude consensus between the parties. That is to say, it is not a material mistake. The mere fact that a party's consent to a contract is based upon a mistaken belief that he or she holds is not a sufficient ground to nullify the contract. However, where such mistaken belief has been induced by the misrepresentation of the other party, the contract is voidable at the instance of the representee. But the cause of action in such a case is misrepresentation, not mistake. On the other hand, where the mistake induced by a misrepresentation is of a material nature, the contract is void ab initio for lack of consensus, provided the error is justus in the sense outlined earlier. Here, the invalidating factor is mistake, not misrepresentation, although, as we have seen, the fact that the misrepresentation was induced by a misrepresentation The fact that the mistake, was induced by a misrepresentation is of vital importance in determining whether or not it has justus. At common law, a provision in a contract to the effect that neither party has made any misrepresentation to the other party is effective, in the absence of fraud, to exclude reliance on misrepresentation as a cause of action. However, it will not prevent a party from leading evidence to show that, as a result of a misrepresentation made by the other party, he or she labored under the Eustace error in regard to the terms of the contract. For if the contract of which it forms part is void for mistake, the exclusion clause is equally devoid of legal effect. As noted before, a failure to draw the attention of the other party to the presence in the contract of the exclusion clause in circumstances where there is a duty to do so constitutes a misrepresentation by silence that renders the other's mistake as to the contents of the contract useless. In the figure below, consider the following scenario. A makes a misrepresentation to B that induces B to enter into an alleged contract with A. There is a clause in the contract that seeks to exclude A's liability for misrepresentation. Okay, then you can just study figure 4.2 on your own time. And then number 4.2.3, remedies for misrepresentation. A contracting party who has been misled into contracting by the misrepresentation of the other party may, in appropriate circumstances, set the contract aside and claim restitution, or raise the misrepresentation as a defense when sued upon the contract, and is in addition entitled to recover damages for any losses caused by the misrepresentation. Number 4.2.3.1, rescission and restitution. Where a party has entered into a contract after a misrepresentation has been made to him or her, such a party is entitled to rescission and restitution, or restitutio in integrum, provided that the following four factors are present. First, misrepresentation by the other party. Secondly, inducement. Third, intention to induce. And fourth, materiality. Okay, first, misrepresentation by the other party. The misrepresentation must have been made by the other party to the contract, or by someone for whose acts he or she is responsible. If it was made by an independent third party, it has no effect on the validity of the contract, unless it induces a material mistake, in which case the contract might conceivably be void for mistake. Of course, an action for damages will lie against the third party where his or her conduct constitutes a delict. Number 2, inducement. The misrepresentation must have induced the representee to enter into the contract. In other words, there must be a causal connection between the making of the misrepresentation and the conclusion of the contract. Thus, no relief will be granted if the representee knew that the statement was false, or if it failed to come to his or her notice, or if it did not influence his or her judgment in any way. If the representation is capable of bearing two meanings, one of which is true and the other false, the representee must show that he or she understood and acted upon it in its false sense. The misrepresentation need not be the sole or even the decisive or dominant cause that induces the representee to enter into the contract. It is sufficient that it was one of the inducing causes. The test for inducement is a subjective one. The question is whether the misrepresentation in the fact induced the representee to enter into the contract, not whether it would have induced a reasonable person to do so. The latter question may relate to the issue of materiality. However, since the representee's ipse dixit alone will seldom be conclusive, it is a matter of inference from all the relevant facts and circumstances whether the actual inducement occurred. And the likely effect of the misrepresentation on a reasonable person is a relevant fact that the court will consider. It is not altogether clear whether the representee may rescind the contract where, but for the misrepresentation, he or she would nevertheless have contracted, albeit on terms more favorable to him or herself. Our modern law continues to uphold the distinction, first drawn by the medieval commentators, between two types of fraud inducing a contract: dolus dans locum in contractoi, and duelis incidents in contractum. If, but for the fraud, the contract would not have been concluded at all, it is duelis dans. If there would still have been a contract but on different terms, it is duelis incidents. The distinction is relevant not only in assessing the damage that may be recovered, but also, it seems, to the remedies available to the defrauded party. Although dicta go both ways, the better view is that incidental fraud, that is, duelis incidents, gives a right only to damages and not to rescission of the contract. If this view prevails, the court will almost certainly apply the distinction with identical effect to misrepresentations made without fraud, employing more suitable terminology such as casual versus incidental misrepresentation, in order to prevent the anomaly of an incidental misrepresentation giving a right to rescind if made innocently, but not if made fraudulently. Number 3. The intention to induce. It is often said that the misrepresentation should be made with the intention of inducing the other party to enter into the contract. The intention that the statement should be acted upon is not the same as the intention to deceive that is an element of fraud. Even a non-fraudulent misrepresentation may be made with a clear intention of inducing the other party to conclude the contract. Where the misrepresentation is made without any such intention to induce, or where it is addressed to a third person and then acted upon by the other party to the contract, reliance upon the representation will usually be unreasonable. This might afford a better explanation for why rescission is not permitted in such circumstances. However, if the unreasonable reliance by the representee was reasonably foreseeable to the representer, it seems fair that rescission should be permitted. Since these considerations relate to the issue of materiality of the misrepresentation, it may be that there is no separate requirement of intention to induce. And number 4, materiality. It is a well-established rule that the representation must be material in order to afford a right to rescind. But the meaning of this requirement is elusive. The concept of materiality is capable of bearing a number of meanings. The meaning most often attributed to materiality in misrepresentation is that the misrepresentation should be of such a nature that it would have the natural and probable effect of inducing a reasonable person to enter into the contract. To interpret the requirement in this way is to insist in effect that reliance on the representation should be reasonable, which seems fair enough but is difficult to reconcile with certain other established rules. For example, it is no defense to a claim based on misrepresentation that the representee had the means of discovering and might with reasonable diligence have discovered that the representation was false, nor to a claim based on fraud that the representee should not have been so gullible. Some writers, in effect, deny the existence of a separate requirement of materiality by arguing that materiality relates to inducement or causation. In other words, a misrepresentation is material when it has the effect of inducing the representee to enter into the contract, and its likely effect on a reasonable person is merely of evidentiary significance. Strong support for this view may be found in two Natal cases. It is submitted that there is some merit in this view, but that its final acceptance should depend on the meaning attached to the requirement of inducement, for the two issues are interrelated. The underlying reason for the insistence on a separate requirement of materiality is the undesirability of allowing the drastic remedy of rescission in respect of even a trivial misrepresentation. If the court grants rescission only in respect of casual misrepresentations, that is, of the duelis dans type, the requirement of materiality is effectively embodied in the concept of inducement, On the other hand, if rescission is allowed even for incidental dualist incidents type misrepresentations, the need for a separate requirement of materiality can hardly be denied. Other writers have suggested that a misrepresentation is material if it meets either of two requirements: either that it was intended to be acted upon by the other party, or that it was of such a nature that it would have induced a reasonable person in the position of the representee to enter into the contract. This is an attractive reinterpretation of the law as traditionally stated. It incorporates the troublesome requirement of intention to induce into the requirement of materiality, and it explains why the victim of a fraud can cancel even if he or she was foolish in believing the misrepresentation to be true. And lastly, fault is not required. Finally, it should be noted that the right to rescind a contract induced by misrepresentation exists irrespective of whether the statement was made fraudulently, negligently, or innocently. In Roman and Roman Dutch law, only a fraudulent misrepresentation afforded the right to restitutio in integrum. But it is not altogether clear whether those systems recognize the concept of misrepresentation as such. However, after English law recognized a right to rescind for innocent misrepresentation on equitable grounds, our courts began to move in the same direction. First, they held that the innocent misrepresentation afforded a defense to a claim on the contract. In Viljoen versus Hillier, Justice Solomon stated, under the Roman law, in such circumstances, the exceptio duelli could have been successfully pleaded to the claim. The duel is consisting not in fraud at the initiation of the contract, but on the fact that it is against good faith for a man to insist upon enforcing a contract which he has secured by his own misrepresentation. Shortly thereafter, the courts took the next logical step and held that a party induced to contract by an innocent misrepresentation is entitled to set the contract aside and claim restitutio in integrum, a rule that is now firmly entrenched in our law. 4.2.3.2 Misrepresentation as a defense. As it has been noted, misrepresentation may constitute an invalidating cause no less than a cause of action. In other words, whenever a representee may rescind a contract for misrepresentation, he or she may also use the misrepresentation as a defense to an action on the contract brought against him or her by the representer. The process of pleading misrepresentation as a defense is generally considered to be a form of rescission. Since a representee who relies on misrepresentation as a defense must allege and prove the same facts that are necessary for the remedy of rescission. However, it may be that a misrepresentation will defeat a claim for specific performance even though it would not ground an action for rescission. Number 4.2.3.3 Damages. Whether the representee chooses to cancel or to abide by the contract, he or she may, in addition, be entitled to recover damages in respect of any patrimonial loss caused by the misrepresentation, depending on the state of mind with which the representation was made. In this regard, the distinction between fraudulent, negligent, and innocent misrepresentation is relevant. First, fraudulent misrepresentation is a deliberate deception that causes another financial harm, is a delict in our law, corresponding to the English tort of deceit, and is actionable under the Actio Legis Aquilae. This, a representee who has been tricked into concluding a prejudicial contract is entitled to, in principle, to damages sounding in delict. The 5 essential elements of the cause of action are as follows. First, representation. Secondly, which is, to the knowledge of the representer, false. Third, which the representer intended the representee to act upon. Fourth, which induced the representee to act. and lastly, that the representee suffered damage as a result. The motive of the representer is irrelevant, provided only that he or she made the assertion without an honest belief in its truth and intended it to be acted upon. It matters not that he or she lacked an intention to cause loss or damage to the representee, but such damage must have followed as a result of the representee acting upon the misrepresentation. Particularly in the case of an implied representation, if the representer was unaware of the import of his or her representation, he or she cannot have intended it to be acted upon. However, such intention need not always be dolus directus. That is, the representer need not have applied his or her will to induce the representee to act upon the representation. It is sufficient if he or she subjectively foresaw such a result and was reckless as to whether the result followed or not. The right to claim damages for fraud is not dependent on the materiality of the representation. In other words, it is no defense that the representee should not, as a reasonable person, have been deceived so easily. Ex hypothesi, the representer intended to deceive the representee. It does not lie in his or her mouth to say that the latter ought not to have been so gullible. An agreement that purports to exclude the right to claim redress for fraud is contrary to public policy, and hence unenforceable. Since fraud is a delict, the measure of damages is the usual delictual rather than the contractual measure. The fundamental difference between the two measures was explained by Van den Heever in Trotman versus Edwick. A litigant who sues on contract sues to have his bargain, or its equivalent in money or money and kind. The litigant who sues on delict sues to recover the loss which he has sustained because of the wrongful conduct of another. In other words, that the amount by which his patrimony has been diminished by such conduct should be restored to him. The victim of fraudulent misrepresentation is thus entitled to be put in the financial position he or she would have occupied had the representation not been made to him or her. But he or she cannot have the representation made good by being put in the position he or she would have occupied had the representation been true, since that is the contractual measure applicable to breach of warranty. The principle is easily stated, but its application in practice to the facts of a particular case of fraud has often caused difficulty, especially where the contract is upheld. As a result, there is a strong tendency to hold that the method of assessment to be employed depends on the particular facts of the case in hand. Nevertheless, in spite of this rather pragmatic approach, a number of guiding principles may have been gleaned from the decided cases and the academic literature. Whether the contract is rescinded or upheld, damages are recoverable in respect of the consequential losses flowing from the fraud, provided that they are not too remote. For example, the reduction in the value of the herd where the representee has been deceived into buying a beast with an infectious disease. Where the contract is rescinded and restitution ordered, the representee's loss on the transaction itself is generally wiped out by the process of restitution, and his or her damages are thus usually limited to wasted costs and other such consequential losses. Where the contract is upheld, on the other hand, the representee may suffer a loss on the transaction itself, for example, by paying more for a thing than it is worth. And it is the assessment of such intrinsic loss that presents the most difficulty. In this regard, the distinction between dolus dans and dolus incidens is once again of importance. Since to be compensable, at all, the loss in question must be casually connected with the fraud. Care must be taken to determine the precise effect of the fraud on the conclusion of the contract. In the case of dual stance, there would have been no contract at all but for the fraud. To remove the effect of the delict, therefore, the representee should be placed in the financial position he or she would have occupied had he or she not contracted. In other words, he or she should be given the financial equivalent of rescission and restitution as compensation for his or her net loss on the overall transaction. This entails awarding the innocent party the value of his or her performance, less any benefits that he or she has received from the other party under the contract. In a case of sale, for example, his or her net loss is the price paid for the mercs, less its actual or fair value at the time of purchase. Both losses and benefits have to be taken into account, since both flow directly from the misrepresentation. This if, in spite of the misrepresentation, the representee has made an overall profit on the transaction, he or she is not entitled to any damages. The so-called swings and roundabouts principle. For example, if he or she has paid 800,000 rand for a house worth 900,000 rand, and he or she would not have bought at all but for a misrepresentation that the house had recently been rewired. He or she cannot recover the 20,000 rand that it has cost to rewire the house, since what he or she loses on the swings, that is 20,000 rand, is more than compensated by what he or she gains on the roundabouts, that is the 100,000 rand. In the case of dualist incidents, on the other hand, where the effect of fraud was merely to influence the terms of a contract which would in any event have been concluded, the representee's loss cannot be measured by comparing the values of the respective performances of the parties, since neither was fully induced by the representation. Rather, one should measure the extent to which the representation inflated the performance that the representee was prepared to make under the contract. In other words, if the representee is a purchaser, his or her loss is the difference between the price he or she actually paid and the price that he or she would have paid but for the misrepresentation, that is, the putative price. Take the case of a bad bargainer. Suppose A offers to buy something worth 100 rand from B for a price of 120 rand. B makes a misrepresentation which, if true, would make the thing worth 150 rand. A then buys it for 180 rand. The loss caused by the misrepresentation was not 80 rand, that is the price paid less actual value, but 60 rand, the price paid less price that would otherwise have been paid. The additional loss of 20 rand, that is the putative price less actual value, would in any event have been incurred due to A's bad bargaining. In the case of a good bargainer, on the other hand, the damages awarded may exceed the difference between the price paid and the actual value of the mercs, since they include an element of loss of profit, that is lucrum cessans. In the example given above, if A's initial offer was less than the actual value of the thing, say 90 rand, and his or her final accepted offer after the misrepresentation was 135 rand, then the representee can recover not just 35 rand, that is the price paid less actual value, but 45 rand. The additional 10 rand represents the profit that he would have made but for the misrepresentation. This is not the same as awarding him or her contractual damages, which would here be 50 rand. That is the difference between the represented and the actual value of the mercs. That is the 150 rand less 100 rand. Indeed, even if the representee has made an overall profit on the transaction in spite of the misrepresentation, he or she may recover damages to the extent that he or she has paid more for the thing than he or she would otherwise have done, since he or she is financially worse off as a result of the fraud. But for the misrepresentation, his or her profit would have been even greater. One cannot set off against this loss of profit the gain that the representee makes on the transaction, since that gain stems not from the misrepresentation but from the conclusion of the contract. Ex hypothesis, the contract was not induced by the misrepresentation. In a duelist incidence situation, therefore, the swings and roundabouts principle is inapplicable. Naturally, it will often be difficult to establish the terms on which the parties would have agreed had the misrepresentation not been made, particularly if there was no prior offer, as will usually be the case. Strictly speaking, it is not sufficient simply to ask what the representee would have offered had the misrepresentation not been made. One should also inquire whether the representer would have accepted such lower offer. For if he or she would not have done so, no contract would have been concluded. The duelist dance situation. However, this is taking logic a bit far, and the courts have understandably balked at saddling the innocent representee with the heavy onus of proving ex post facto when the parties are at daggers drawn in litigation. The subjective state of mind of the wrongdoer at the time of the contract. It has accordingly been held that in the ordinary case, the representee need merely establish the amount that he or she would have offered but for the misrepresentation. Only if the representer then shows that such offer is lower than the market value of the mercs. To use the example of sale, will it be necessary for the representee to prove that his or her lower offer would probably have been accepted? On the other hand, the courts will not simply accept the ipse dixit of the representee as to what he or she would otherwise have offered. In the absence of satisfactory evidence to the contrary, the courts will assume that the price actually paid reflected the value of the thing in its represented condition, and therefore that had the misrepresentation not been made, the mercs would have been sold at its true or market value. On this assumption that the parties bargained as reasonable persons, the measure of damages for duelist incidents is the same as for duelist dance. The price paid less actual value. And then we just have a counterpoint there. Do the courts merely pay lip service to these principles? Although the foregoing principles are not hard and fast rules, they have attracted a wide measure of judicial support. However, it has been said that in attempting to apply them, the courts have often in effect awarded the contractual measure of damages, a charge that cannot simply be dismissed with the trite observation that, in a particular case, the delictual and contractual measures may yield the same quantum of damages. Even when the courts adopt a different method of assessment, they appear at times to fall into the same trap. In Ranger's case, for example, it was held that where a thing is misrepresented to be free from defects, the damage may be measured by the cost of removing the defect. With respect, it is submitted that despite the obvious practicality of such an approach, it amounts to making the representation good, that is the contractual measure. Number 2. Negligent misrepresentation. Until the decision in Bayer South Africa Proprietary Limited versus Frost, there remained some residual doubt as to whether delictual damages might be awarded in respect of negligent misrepresentation inducing a contract. The issue was but one aspect of a much wider problem, namely the actionability at all in delict of a negligent misstatement causing purely economic or financial loss, as opposed to a negligent act causing injury to a person or property. But with the added complication in this case that the misstatement is made in a contractual context. For many years, our courts were reluctant to grant delictual damages for a negligent misstatement causing economic loss. To a large extent, this reluctance stemmed from a fear that the recognition of such an action may result in liability in an indeterminate amount for an indeterminate time to an indeterminate clause to an indeterminate class. It was also strongly influenced by the decision of the House of Lords in Derry versus Peake, which was generally interpreted as ruling out damages in tort for a merely negligent as opposed to a fraudulent statement. However, after English law dramatically changed course in Hedley, Byrne and Co. Limited versus Heller and Partners Limited, our law began to follow suit in Administrateur Natal versus Trust Bank van Afrika BPK. The actionability intellect of a negligent misstatement causing purely economic loss was at last recognized in unequivocal terms, subject to the usual elements of Aquilian liability being satisfied. With the broader question settled, the focus of attention shifted to the wrongfulness of otherwise of a negligent misrepresentation inducing a contract. In Administrateur Natal, that issue had been deliberately left open, but the appellate division had earlier in Haman versus Moorman made its attitude on the point quite plain. The existing law grants what appears to be adequate protection in the field of contract to a party to whom a misrepresentation is made. Thus, a contracting party may safeguard himself against loss by simply taking the elementary precaution of requiring the representer to guarantee the truth of his representations. Adequate remedies are available where the misrepresentations are tainted with Duress, and in appropriate circumstances an aggrieved party is granted relief in the case of an innocent misrepresentation. I am by no means satisfied that the practical necessity of a remedy of the kind contended for has been demonstrated, nor that its recognition might not result in more ills than the one it is intended to remedy, namely the failure of the unwary representee to have proper regard to his own interests in the field of contract. These obiter dicta were severely criticized, and justifiably so. The existing remedies available to the victim of a negligent misrepresentation could by no means be considered adequate. Neither rescission of the contract, a drastic step in itself, nor price reduction under the actio quanti minoris in the case of sale are of much comfort to the representee who has suffered consequential losses through reliance on the misrepresentation. Nor can one reasonably expect a contracting party to insist that the other party guarantee every statement that he or she makes. If parties cannot rely on statements made during the bargaining process, how can business be conducted in a spirit of good faith? Of course, the law recognizes that in seeking the most advantageous deal possible, contracting parties are prone to exaggeration and a certain looseness of language, hence the immunity granted in respect of mere puffs. Some skepticism about precontractual statements is thus called for, but it surely could not be the law that parties are free to pepper each other with careless misstatements of fact. For a while the provincial courts reluctantly gave effect to the Haman Dicta. After the seminal decision in Administrateur Natal versus Trust Bank van Afrika BPK. However, the Cape Provincial Division felt justified in departing from the Haman line, holding that in certain circumstances a party induced to contract by a negligent misrepresentation is entitled to delictual damages. The court was fortified in its decision by the fact that in England, the Court of Appeal had similarly extended the Hedley-Byrne doctrine to the pre-contractual sphere. In 1992, this welcome development finally received the seal of approval from the Appellate Division in the case of Bayer South Africa Proprietary Limited versus Frost. The court held that there was no good reason why the general action for negligent misstatements recognized in the trust bank case contract. This was subject, of course, to all the requirements for equivalent liability being satisfied, with particular emphasis being placed on the elements of wrongfulness and causation, affording the courts the necessary means of controlling the scope of this new form of liability. Since the new cause of action is delictual in character, the damages awarded for negligent misrepresentation will be measured in the same manner as the delictual damages for fraud. Number 3. Innocent misrepresentation. A more difficult question is whether damages of some sort may be recovered in respect of a wholly innocent misrepresentation. That damages in the true sense of the word cannot be recovered seems certain. Since ex hypothesi, the misrepresentation is not a term of the contract and is made without dualis or culpa, there is neither the breach of contract necessary for contractual damage, nor the culpable conduct required to sustain an equivalent action for delictual damages. Consequential losses suffered in reliance on an innocent misrepresentation are thus not compensable, and must lie where they fall. Compensable. Sorry. What remains to be settled, however, is whether a party induced to contract by an innocent misrepresentation is entitled, instead of rescinding the contract, to abide by it and claim the financial equivalent of rescission and restitution. Restitutional damages, partial restitution, or reduction of performance, or quanti minoris type damages, as such relief has at various times been called. In the special case of sale, as we shall see, such relief is now sometimes available under the actio quanti minoris. However, outside a Delitian context, the position is less clear. There are many dicta denying damages for innocent misrepresentation. On the other hand, Chief Justice Maasdorp took the opposite view in Brink versus Robinson. Why should the representee not get damages, even if the representation was innocently made? He has nothing to do with the representation. He asks for information and he gets the misrepresentation. It does not matter to him whether it was innocently made or not, and I fail to see why he should be made to suffer the damages for that. The problem with almost all of these dicta is that they do not make it clear whether the damages to which they refer are damages proper, that is, compensatory damages, or merely restitutional damages. If Chief Justice Maasdorp had in mind an award for compensatory damages, his statement goes too far. But by the same token, most of the statements against allowing damages are open to the interpretation that they refer only to damages proper and not restitutional damages. And then there's just a small pause for reflection. Should restitutional damages be awarded for innocent misrepresentation? In English law, the courts have now have the power to award restitutional damages in lieu of rescission for an innocent misrepresentation under Section 2, Subsection 2 of the Misrepresentation Act of 1967. Calls for similar relief have been made by several South African writers. Finding a doctrinal basis for such relief presents a problem. However, some writers have suggested basing it on enrichment, but that cannot be done without undermining the requirement that the enrichment should be legally unjustified or sine causa. Equally unconvincing is the argument that the making of a misrepresentation constitutes a hazardous activity that so appreciably increases the risk of harm to the representee that it justifies the imposition of a strict delictual liability. The best approach, it is submitted, is the non-dogmatic one favored by many of the writers cited above, namely that the right to restitutional damages or partial restitution or reduction of performance should be recognized as a logical and equitable extension of the existing right to rescind a contract induced by an innocent misrepresentation. Having recognized the drastic right of rescission on grounds of equity, the courts should, on the same basis, allow the representee to opt instead for the less extreme course of affirming the contract and claiming the financial equivalent of restitutio in integrum. Otherwise, the representee may be driven to set aside an entire transaction in order to obtain redress for a relatively minor, but nonetheless prejudicial misrepresentation which is surely not in the interests of either party. The considerations of equity that have induced the courts to recognize a right of rescission apply equally strongly to the remedy of restitutional damages. While it is, of course, true that the representer has behaved innocently, so too has the representee. Why should he have to suffer a loss to the corresponding advantage of the representer? To order restitution would not punish the representer or even make one of two innocent parties bear a loss, but would simply restore an economic balance that has been disturbed. If it is morally wrong for a person to resist rescission of a contract induced by his or her own innocent misrepresentation, it is surely equally so for him or her to retain a benefit obtained in the same way. It's the end of the pause for reflection. The case for allowing restitutional damages is strengthened by the decision in Fame Proprietary Limited versus Pazes. As we have seen, the appellate division decided in that case that a purchaser who has been induced to contract by a seller's unfounded dictum et promissum may invoke the Delictual remedies. If he or she would not otherwise have bought at all, he or she may cancel the contract with the actio redebitoria, a largely superfluous remedy in view of the right to rescind for misrepresentation. More significantly, the purchaser may instead choose to abide by the contract and claim a reduction of the purchase price with the actio quanti minoris. Since a dictum et promissum, as defined in Pame, is essentially a positive misrepresentation as to the quality of the mercs and is actionable even if made without fraud or negligence, the purchaser is in effect afforded a remedy in damages for innocent misrepresentation. Indeed, it is when the dictum et promissum constitutes an innocent misrepresentation that the purchaser is most likely to invoke the actio quanti minoris. If the statement was warranted to be correct, he or she will surely sue in contract, and if it was made fraudulently or even negligently, he or she is more likely to sue in delict, since he or she will then be able to recover consequential losses as well. The relief obtainable under the actio quanti minoris is limited to a reduction of the price. In absence of fraud or warranty, the purchaser is not entitled to consequential damages except perhaps where the seller is a manufacturer or a merchant seller who publicly professes to have attributes of skill and expert knowledge in relation to the kind of goods sold. The measure of reduction is not the difference between the agreed price and the price that would have been paid but for the misstatement, as in the cases of Duress incidents, but rather the difference between the price paid and the actual value of the mercs. This, where the purchaser would in any event have paid more for the mercs than it is worth, it will suit him or her better to allege an innocent dictum et promissum than a fraudulent misrepresentation, a result rightly considered a little strange. The Delictual actions apply only to the contract of sale, and perhaps exchange, and only to misrepresentations that fall within the concept of a dictum et promissum. Thus, the statement must be made by a seller, and must concern the quality of the mercs. It follows that the actio quanti minoris can hardly serve as a general remedy for innocent misrepresentation. Nevertheless, the recognition of a right to restitutional damages on the part of the purchaser raises the question why the other representees should not have a similar right. Apart from the historical one, what special factors in the contract of sale justify the preferential treatment of the purchaser? It is noteworthy that the court in Pame was clearly influenced by equitable considerations in effectively extending the scope of Delitian relief, though it based its decisions on old authority and expressly made no comment on the alternative claim for the same sum as damages for innocent misrepresentation. Number 4.2.4 Misrepresentation by silence or non-disclosure. Failure to disclose a material fact when under a legal duty to do so constitutes a misrepresentation by silence, a form of commissio per omissionem. In principle, therefore, a party who has been induced to contract by the unlawful non-disclosure of material information is entitled to the same remedies as the victim of any other misrepresentation. The problem, however, is to establish that the failure to speak was unlawful or wrongful in the circumstances. As in the fields of law, there is some reluctance to impose liability for a mere omission as opposed to a positive act of commission. This is reflected in the general rule that where conduct takes the form of an omission, such conduct is prima facie lawful. Accordingly, it is not the norm that one contracting party need tell the other party all he knows about anything that may be material. In other words, the general rule is still that the contracting party is under no legal duty to disclose information known to him or herself, but not to the other party, even if he or she is aware that the disclosure would influence the other's decision whether or on what terms to enter the contract. However, the rule has always been subject to a number of exceptions, and as the policy considerations underlying these exceptions have become more apparent, the courts have gradually synthesized them into a general test for liability. The exceptional cases where the law imposes a duty to speak include the following. Number 1. Where the contract is one of insurance, agency, partnership, or engagement. A party seeking insurance, for example, must disclose any facts that could reasonably be expected to influence the risk, whether asked about such a fact or not. These contracts are traditionally expressed to be contracts of the utmost good faith. But the label is misleading. In modern law, all contracts are bona fide, and there are no degrees of good faith. Number 2. Where there is a fiduciary relationship between the parties, such as between attorney and client or guardian and ward, this category clearly overlaps with the previous one. Number 3. Where a statute imposes a duty of disclosure. For example, the Companies Act specifies matters that must be disclosed in a prospectus inviting the public to subscribe for shares in a company. Number 4. Where a seller has knowledge of a latent defect in the thing he or she is selling. In terms of the Delitian edict, he or she is liable for such defects even if ignorant of their existence. But knowledge transforms silence into fraud, and this widens the scope of his or her liability. At any rate, where the knowledge is deliberately withheld to induce the sale. Number 5. Where an applicant for credit is an unrehabilitated insolvent. The applicant's status must be disclosed. Number 6. Where a party's prior conduct or statement renders silence misleading. There are a number of situations on the borderline between active and passive misrepresentation, where the prior conduct or statement of a party, though often iniquitous in itself, is such as to render silence on his or her part highly misleading. First, where the prior conduct of a party has the effect of concealing facts that would otherwise be apparent to the other party. Secondly, where a party has by his or her prior conduct or representation led the other not to expect to find a particular clause in a written contract that he or she signs. Here there is a duty to draw attention to the clause in question. And lastly, where silence distorts a positive representation. For example, where a statement is literally true but misleading because it is not the whole truth, or because it implies further facts that are false, or where a change of circumstances falsifies a statement that was true when it was made. In all all these cases, the duty to disclose does not derive from an implied term of the contract. It is simply imposed ex lege. Okay. The question that inevitably arises is whether there is not some common denominator or principle underlying these exceptional cases that could serve as a general test for a duty to disclose in other cases too. No doubt the basic idea is that contracting parties are required to behave in accordance with the dictates of good faith, but the principle needs to be formulated in rather more concrete terms if it is to be of any direct assistance. A very helpful formulation suggested many years ago by Milner is that a duty of disclosure exists where there is an involuntary reliance of the one party on the frank disclosure of certain facts necessarily lying within the exclusive knowledge of the other, such that in fair dealing the former's right to have such information communicated to him would be mutually recognized by honest men in the circumstances. And conversely, a party may quite lawfully remain silent where matters are equally open to common observation, or ascertainable by ordinary diligence, or accessible to both parties alike, so that each could reasonably be expected to exercise his or her own judgment in the matter. The test of involuntary resilience found favor with our courts and has been applied in virtually all the subsequent cases involving non-disclosure. Its influence is readily apparent in the general test for liability recently adopted by the Supreme Court of Appeal. A party is expected to speak when the information he has to impart falls within his exclusive knowledge, so that in a practical business sense the other party has him as his only source, and the information moreover is such that the right to have it communicated to him would be mutually recognized by honest men in the circumstances. As Christie points out, the test accords well not only with the principle underlying the onerous duty of disclosure in the so-called uberi fidei contracts, but also with the softening of the distinction between these and other contracts. The reason that certain contracts always attract a duty of disclosure is to be found not in the uberi fidei's label or in a higher standard of honesty. There are no degrees of good faith, but rather in the fact that in these contracts there is invariably present a relationship of dependency and trust, and hence the elements of involuntary reliance identified by Milner. In other contracts, that element may sometimes be present, but not always. Thus, whether or not a duty to disclose exists depends less on the type of contract in question than on the actual circumstances surrounding a particular transaction. So, no hard and fast criteria can be established to determine where what is merely unethical becomes unlawful. Milner's test is necessarily somewhat vague and flexible, like more general tests for the wrongfulness of an omission in the law of delict. As Janssen pointed out in Meskin's case, both tests ultimately rest on the same basis, namely the mores of today. There is some authority for the view that a prospective purchaser need not disclose to the seller facts that increase the value of the mercs, but in light of what has been said above, it would seem that there is no fixed rule in this regard. But in most cases, of course, the seller can reasonably be expected to familiarize him or herself with the thing he or she is selling, and thus to have ascertained the true facts for him or herself. But that will not always be the case. Finally, the impression is sometimes created that all cases of unlawful disclosure necessarily involve fraud. This is not so, however, for it has been held that even an innocent or negligent failure to disclose a material fact may be unlawful in the circumstances of a particular case. Number 4.3. Duress. Duress or metus is improper pressure that amounts to intimidation. A party who gives his or her consent to a contract under duress does so not through the free exercise of his or her own will, but through fear inspired by an illegitimate threat. Apart from the very rare cases where the fear is so extreme as to exclude consensus altogether, a contract induced by duress is valid, since, in the eyes of the law, a forced consent is none the less an effective consent. Voluntas cauda est tamen voluntas, or something like that. However, in the view of the fact that the consent was obtained by improper means, the contract is voidable at the option of the threatened party. He or she may thus set aside the contract if he or she so wishes, and claim restitution of what he or she has given, or may resist the enforcement of the contract by the other party. And in any event, he or she may also, in a proper case, recover damages, since, like fraud, duress is a delict giving rise to the Aquilian action. For these consequences to arise, however, it is essential that the threat should be both unlawful and an effective cause of the contract, in the sense that, but for it, the threatened party would not have contracted at all, or at least not on the terms that he or she did. What other requirements must be met is not altogether clear. Writing in the 1930s, Sir John Wessels said that a party who alleges duress must establish the following elements. First, actual violence or reasonable fear. Secondly, the fear must be caused by the threat of some considerable evil to the party or his family. Third, it must be the threat of an imminent or inevitable evil. Fourth, the threat or intimidation must be contra bona moris. And fifth, the moral pressure used must have caused damage. Okay, then there's just a small pause for reflection. Is Wessels' formulation for the requirements for duress satisfactory? Wessels' formulation of the test for duress was embraced in the leading case of Broderick versus Smits, N.O. It is generally agreed, however, that the formulation is unsatisfactory and that many of its elements are open to serious question. As the number of reported cases on duress is relatively small, few of these elements have been subjected to close scrutiny by the courts. Academic commentators have suggested reformulations of the test that accord more closely with trends in legal thought here and in other jurisdictions. Nevertheless, Wessels' summary may serve as a useful basis for a discussion of the various aspects of the problem of duress in the formulation of a contract. Number 4.3.1. The nature of coercion. Duress necessarily involves an element of coercion, but it is a coercion of the will rather than the body of the victim. The force employed is what the old writers called vis compulsiva, as opposed to vis absoluta. Vis absoluta is overwhelming physical force. For example, where A grips a pen in the hand of B and forces it to sign B's name on a document. In such circumstances, there would, of course, be no contract, for B has not acted at all. In the case of duress, on the other hand, the coercion operates on the mind of the victim by forcing him or her to choose between two evils, entering into the contract or suffering some harm. The coercion is this by threat rather than by physical force. Even where violence is used to pressurize the victim, the factor that induces his or her consent is the threat, expressed or implied, that such violence will be continued or repeated unless he or she agrees to the contract. 4.3.2. The reasonableness of the fear. The notion that the threat should be sufficiently grave to affect the mind of a reasonably steadfast person is supported by a number of authorities, ancient and modern, some of whom add that account ought to be taken of the age, sex, and other personal attributes of the victim. According to Grotius, However, the fear need not be reasonable, and this view is to be preferred, since to hold otherwise is to afford an unscrupulous party a license to exploit the unreasonable fears of another. Provided, therefore, that the threat was made with the intention and effect of inducing the contract, the person who issued it should not be permitted to argue that his or her victim ought not to be frightened so easily. Naturally, the more unreasonable the fear, the greater will be the reluctance of the court to accept that it actually induced the contract, but that is a matter of proof rather than substantive law. Number 4.3.3. The object of the threat. It is said that the threat must be directed at the life, bodily integrity, or property of the person concerned or his or her immediate family. Of the old writers, Grotius alone considers a threat to one's honor as sufficient. Why there should be this distinction between various interests is unclear. The ultimate question is surely whether a party's consent was obtained by improper means. Furthermore, it is inconceivable that a court today would deny relief merely because the threat was directed at a distant relative or even a stranger, particularly where the threat was one of physical violence to the person concerned. In the case of threat to property or duress of goods, as it is known, the courts have insisted on an unequivocal protest at the time of payment or entry into the contract as proof of the involuntary nature of the transaction. There is this difference between the case of menaces to the person and that of duress of goods, that in the former the menaces might per se be enough to prove the absence of free consent, although no objection may have been made to the payment at the time it was made, whereas in the latter case all reasons for fear or bodily danger being absent, it is impossible to know whether the payment is voluntary or involuntarily made, unless some unequivocal objection to the payment is raised at the time it is being made. It was stated in Hendricks versus Barnett. However, this distinction between the two forms of duress relates to the matter of proof rather than the actual ingredients of the cause of action. Silence is not necessarily indicative of free consent. Where no protest was made, therefore, relief should still be granted if there is satisfactory evidence to establish that the contract was concluded as a result of duress. Whether a threat to the purely economic interests of the other party can constitute duress in our law remains an open question. English and American law now recognize that economic pressure may in appropriate cases constitute so-called economic duress. And our Supreme Court of Appeal has conceded that in principle there is no reason why our law should not follow suit. The court went on to say, however, that such cases are likely to be rare, since in a competitive economy it is generally neither unlawful nor unconscionable to cause another economic harm, and that hard bargaining is not equivalent to duress. 4.3.4. The imminence of the harm. The statement by Wessels that the threat should be of an imminent or inevitable evil is based on the old Roman authority, and no doubt reflects the idea that where possible the party threatened should seek legal protection rather than yield to the threat. Whether there is a fixed rule in this regard is to be doubted, however, for writers such as Foote and van Leeuwen appeared to consider otherwise. It is submitted that relief should be granted even where the threatened harm was neither imminent nor inevitable, provided that the threatened party had no reasonable or acceptable alternatives available other than succumbing to the threat by entering into the contract. Number 4.3.5. The unlawfulness of the threats. The threat must be unlawful or contra bonus mores. A person who enters in a contract through fear inspired by a lawful threat is no ground for complaint, since the factor that renders a contract voidable for duress is not per se, but the obtaining of the victim's consent by improper means. A threat is unlawful not only if the threatened conduct is unlawful in itself, for example, a threat to murder or assault someone, but also if the threat is made for an illegitimate purpose. A threat to enforce one's right by bringing a civil action is not unlawful, except perhaps in the most unusual circumstances. Therefore, a settlement reached to stave off the threatened action is not voidable for duress. A threat to institute a criminal prosecution unless the debt is satisfied is another matter altogether. It is generally agreed that such a threat is unlawful if it is used to extort a benefit to which the creditor is not entitled, or if the debtor is innocent of the alleged crime. But if the debtor has in fact committed a crime and the creditor seeks to obtain no more than his or her due, for example, where an employer threatens to prosecute his or her employee for theft unless the latter repays or agrees to repay a definite sum of money that he or she has stolen from the employer, there is a difference of opinion. In a number of Transvaal and Natal cases, the view has been taken that in these circumstances a threat of criminal prosecution is not unlawful. In the Cape, on the other hand, some doubt has been expressed about the correctness of these cases, and this doubt is shared by a number of academic writers. It is argued persuasively that the use of the criminal process to enforce strictly private rights is contrary to the public interest and thus unlawful, and that quite apart from duress, a contract induced by a threat of a criminal prosecution will normally be void for illegality, on the grounds that it amounts in effect to an agreement to stifle a prosecution or to compound a crime. 4.3.6 Damage. Financial loss is of course an essential element of a claim for equivalent damages, but in a number of cases it has been suggested, following foot and vessels, that damage is required even for restitutio in integrum. Why this should be so is not clear, since the basis of the latter remedy is improperly obtained consensus, not the wrongful infliction of harm. It is submitted that the only form in which this requirement can be accepted is that adopted in Broodryk v. Smits. The person alleging duress must show that he or she has become subject to obligations that he or she would not otherwise have incurred. In other words, the duress must have induced the contract, the mere fact of contracting being sufficient to satisfy the requirement of damage. Number 4.3.7 Duress by a third party. Where the duress emanates from an outsider acting independently and without the knowledge of the other contracting party, one would expect that, as in the case of misrepresentation, the only remedy would be an action for damages against the third party. However, the old authorities afforded the remedy of restitutio in integrum in these circumstances. The matter has not yet come before our courts. When it does, it seems likely that the old approach will be rejected, except in cases such as marriage, where public policy demands that the contract should be voidable, irrespective of the source of the duress. Number 4.4 Undue influence. Like duress, undue influence is a form of improper pressure brought to bear upon a person in order to induce him or her to enter into a contract. However, in the case of undue influence, the pressure is more subtle, involving an insidious erosion of the victim's ability to exercise a free and independent judgment in the matter, rather than threats or intimidation. In most instances of undue influence, there is a close relationship between the parties, either a fiduciary relationship, as between a doctor and patient or attorney and client, or one of respect and reverence, as in the case of parent and child, guardian and ward, or religious leader and disciple, which entitles or obliges the one party to advise and assist the other, and the former then misuses his or her superior position to influence and undermine the will of the latter. Number 4.4.1 Origins of the doctrine. The term undue influence, unknown to our old authorities, comes to us from English law, where the originally narrow scope of the common law concept of duress led the courts of equity to develop the more elastic doctrine of undue influence. References to undue influence as a consensual defect giving rise to restitutio in integrum gradually found their way into our law reports and textbooks. But it was not until 1948 that a court firmly declared that a contract could be set aside on this ground. Although controversial, the decision was confirmed by the appellate division in Praller versus Jordan, where a majority of the courts held that the grounds for restitutio in integrum in Roman Dutch law were wide enough to cover what is today referred to as undue influence. Whether or not this finding is historically correct, the matter has been put beyond all dispute by the subsequent case of Patel versus Grobbelaar, which confirms that the doctrine of undue influence undoubtedly forms part of our modern law. And indeed, the facts of Patel's case indicate the need for such a doctrine and the overall desirability of its recognition by our courts. The laissez-faire attitude displayed by van den Heever in Praller's case is neither attractive nor appropriate in modern times, if it ever was. Okay. Number 4.4.2 Requirements. According to the Patel case, adopting the phraseology used in Praller versus Jordan, sorry for that pronunciation, a party who seeks to set aside a contract on the ground of undue influence must establish, first, that the other party obtained an influence over him or her. Secondly, that this influence weakened his or her powers of resistance and rendered his or her will compliant. And secondly, that the other party used this influence in an unscrupulous manner to persuade him or her to agree to a transaction that, firstly, was prejudicial to him or her, and secondly, which he or she would not have concluded with a normal freedom of will. Since the basis of the action is vitiated consent, it is not clear why prejudice should be proven. Once again, it is submitted that mere inducement to contract should suffice. In English law, the existence of a special relationship between the parties gives rise to a rebuttable presumption of undue influence. In our law, it seems fairly clear that no such principle applies, the onus being on the party who alleges undue influence to prove that it occurred. But of course, the existence of a confidential relationship between the parties is a relevant factor in discharging that onus. As this rule demonstrates, we have merely adopted the term undue influence from English law and not the detailed rules in connection therewith. Where the undue influence is brought to bear by an outsider, the party influenced may set aside the contract only if the other contracting party was aware at the time of the transaction that the influence had been exercised. Whether an action for damages will lie against the outsider in such circumstances or against the other party to the contract when he or she who has exercised the influence has not yet been decided. But it seems fairly clear that where the undue influence has caused loss, the Aquilian action will lie, since the conduct of the guilty party is both deliberate and wrongful. Being a somewhat elastic concept, undue influence may in some cases be almost indistinguishable from fraud, while in others it may overlap with duress. As pointed out earlier, however, it is the absence of intimidation that distinguishes it from duress. This, for example, pressure exerted by one who is in a position of authority over another will usually constitute undue influence. But if the pressure is accompanied by threats or intimidation, we have a case of duress, the so-called mitis reverentialis. Number 4.4.3 Abuse of circumstance. Closely akin to undue influence, but often treated as a form of duress, is a situation where A unconscionably exploits an emergency situation in which B finds him or herself to secure B's consent to a prejudicial contract, the emergency not having been caused by A. A classic example of such a situation is afforded by Blackburn versus Mitchell. A ship was stranded in Table Bay and in imminent danger of destruction. The captain of a tug that came to the rescue offered to tow the ship to safety for a sum of £2,000. The master of the ship was outraged, considering the sum exorbitant, but he ultimately signed under protest an unconditional promise to pay the amount demanded, and adding, however, that the money would never be paid. The ship was saved and the promise dishonoured. When the tug captain sued, the court held, applying English maritime law, that the master of the ship was not bound by the contract, but was liable to pay a reasonable sum for services rendered, the amount being fixed at £1,000. Our common law on the point is by no means clear, but the general tenor appears to be that the contract is enforceable. Pothier states that the agreement is valid, but that the promised performance of the victim must be reduced to what is reasonable. In a thorough study of the problem, van Steenhuisen suggested that these cases involving the exploitation of an emergency and cases of undue influence are both species of a single genus of consensual defect that he calls abuse of circumstances. The two situations are certainly very similar, and it appears equitable to allow the exploited party to escape from the contract, but it need not follow that identical rules apply equally to both cases. As yet, van Steenhuisen's thesis has not found acceptance by the courts. It is interesting to note that in English law, the equitable doctrine of undue influence extends to unconscionable bargains in certain cases in which one party is in a position to exploit a particular weakness of the other. Indeed, some dicta lend some support to the view that a contracting party should be entitled to relief if the other has taken unfair advantage of the fact that there is a marked inequality of bargaining power between them. Number 4.5. Commercial bribery. In plaaslike boeredienste EDMS BPK versus Chemforce BPK, the appellate division, upholding the rights of a party to set aside a contract induced by the bribery of its agent, held that the basis of the rights is not fraud, as in English law, but rather the wrongful and immoral means used to secure the agreement. In Extile Industrial Proprietary Limited versus Crown Mills Proprietary Limited, the court confirmed that commercial bribery is a distinct ground for rescinding a contract, and that it has the following elements. First, a reward. Secondly, paid or promised. Third, by one party, the briber. Fourth, to another, the agent, who may be an agent in the true sense or merely a go-between or facilitator. Number 5, who is able to exert influence over. Number 6, a third party, the principal. Number 7, with the intention that the agent. Number 8, should induce the principal. Number 9, without the latter's knowledge. And number 10, for the direct or indirect benefit of the briber. Number 11, to enter into or maintain or alter a contractual relationship. Number 12, with the briber, his principal associate or subordinate. Number 4.6, the road ahead, further grounds for rescission. As noted before, and as borne out by the discussion above, the number of grounds on which restitutio in integrum may be claimed has shown a gradual increase over the course of time. That should come as no surprise if one accepts that the common denominator linking the various grounds is that in each case the consent of a party to a contract has been improperly obtained. For common sense indicates that there can be no closed list of such instances. As more grounds for rescission have come to be recognized, a general principle has begun to emerge, that a person should not be held bound to a contract against their will, when their consent to the contract has been obtained by means that the law considers improper or illegitimate. The existence of such a general principle inevitably opens the door to the recognition of further grounds for rescission. Already, some are clamoring for recognition. Economic duress and abuse of circumstances spring immediately to mind. There can be little doubt that in future new grounds for rescission will be recognized, particularly in the view of the resurgence of the principle of good faith in contract. But as observed earlier, it is far less certain that the various grounds will be subsumed under one general ground for rescission. Number 4.7. The consumer's right to fair and honest dealing under the Consumer Protection Act. The Consumer Protection Act has a number of provisions that overlap considerably with the common law relating to improperly obtained consensus. Section 40 of the CPA prohibits various forms of unconscionable conduct on the part of suppliers or their agents. They must not use physical force against the consumer, coercion, undue influence, pressure, duress, or harassment, unfair tactics, or any other similar conduct in connection with, among other things, the negotiation, conclusion, execution, or enforcement of an agreement to supply goods or services to a consumer. In addition, it is unconscionable for a supplier knowingly to take advantage of the fact that a consumer was substantially unable to protect his or her own interests due to a physical or mental disability, illiteracy, ignorance, inability to understand the language of an agreement, or any other similar factor. Section 41 similarly has provisions prohibiting misrepresentation and non-disclosure of material facts to consumers. In substance, these provisions appear to go further than the existing common law in allowing a contract to be attacked on grounds of harassment, unfair tactics, or any other similar conduct. The procedures laid down for their enforcement are also different. Without prejudice to their common law remedies, consumers are now afforded other means of redress through various consumer protection institutions, from ombuds and consumer courts to the National Consumer Commission and the National Consumer Tribunal. Investigations of complaints received by the Commission may lead to negotiated settlements that can be confirmed as consent orders by the tribunal or court concerned. Suppliers suspected of engaging in prohibited conduct will be issued with compliance notices by the Commission, and disregard of such a notice may result in the imposition of an administrative fine or even criminal prosecution.